So there's always a balancing test. People are not always well served by going to trial, especially in a case where they would be convicted. Usually people who go to trial and lose get punished more heavily than people who work something out. So if we believe that the client is really in danger of getting convicted, then we would encourage them to consider a plea deal. If the plea deal is unreasonable, then we push back. And if we can't get something reasonable, then we sometimes go to trial. I had a case, it's probably been 15 years ago now, where this young man was accused of breaking in with his friends into a house. And the policy of the prosecutor's office at that time was any residential breaking in, either at night or during the day, would always result in a felony offer. They would never come off with it. And my client was very young. I think he was probably 16 or 17. And to answer the confusion, if people are wondering, didn't I just say I don't do juvenile cases? At the time that we did those, anybody 16 or older was treated as an adult for criminal court. So the prosecutor for the 16 or 17-year-old would not offer him a misdemeanor. And he'd never been in trouble. He was a good student. He had a bright future. And I wouldn't do it. I just absolutely refused. We went to trial because they would not offer a misdemeanor in that case. And we ended up hanging the jury. The facts in that case were the co-defendants testified that my client was involved, and his father was able to testify that his son had explained that he was with his friends. His friends were going to break into a place, that my client went home during the breaking and entering and then met his friends later and got arrested with everybody else. And the jury at least thought that was plausible enough that they didn't convict him. And then once we had gone through a trial and the jury wasn't convinced beyond a reasonable doubt, the prosecutor offered a misdemeanor, and we ended up pleading guilty to the misdemeanor, which is what I thought was the reasonable offer to begin with. I think there's always a right price. You know, there's always a deal, that there's always the right plea. Sometimes the plea is case dismissed. And sometimes the plea is, I plead guilty, please, please, please have mercy on me. But usually there is something in the middle that we ought to agree to. And when there isn't, it's because somebody doesn't have a realistic picture of what's going to happen at the trial. With incriminating technology and photos and videos and DNA, we often have bigger piles of evidence that we have to go against. But there is also a phenomenon where now, because of all the true crime and the police procedurals and CSI and NCSI, juries have an expectation that they're going to see video and they're going to see DNA. And when they don't see it, they are less inclined to find beyond a reasonable doubt that the police prove the case.
Well, how does the process work, though? Does the defense attorney usually make the first move to try to make a deal?
I guess it depends on the case. The process is that we get to a point where we get the discovery. The discovery is the report of the information that the prosecution has to provide, telling us what the case is about and what their evidence consists of. And we look through it. We see if we think that there's anything missing. We interview witnesses independently to see if they actually are going to repeat and uphold the statement that they gave to the police when they were interviewed. And then we talk about whether we think this is going to be enough to convict. And if we think that there is a problem with the state's case, then we'll think about whether we think a jury is likely to convict. Usually the state will make an offer. In fact, almost always the state will make an offer of some kind. If we think the offer is reasonable, we'll tell our client. If we think the offer is not reasonable, but it's close, then we can negotiate back and forth. And if we're able to get to something that the client can live with, then we work something out. And if not, that's when we go to trial.